started, welcome to, I think, probably only the second brown bag we've had this fiscal year. Last year we did probably 3 or 4. This year has been a busy year and we haven't had a chance to have as many, but we're happy to have this one. We have with us to talk to you today Commissioner Feldblum. She's going to talk to you about the ADA Amendments Act. She claims that it's fun and easy. We'll find out if it's actually fun and easy. She's going to give you sort of a quick background, some foundational information about the ADA Amendments Act, but I think a lot of people in the room probably have a good working knowledge. So she'll talk for about 20 minutes, and then we're going to open the floor for questions. So hopefully you all came prepared with questions. The slideshow that she's going to use, we're going to email out to everyone after the fact, okay? So no need to ask me for that later. And with that, I will turn it over to Commissioner Feldblum.
Thank you. And this mic is working. Excellent. Okay, well, I have no idea if it can be fun and easy, but that's my goal. I absolutely want to make sure that we have time for the questions because, as Jolinda said, and Jolinda does just amazing, wonderful stuff in terms of training. I love it. And you guys who are over there, you might want to come over here just so that you're not craning your neck, you know, because I apparently have to stay on this side, I've been told, in terms of the camera. So I'm going to go through this slideshow somewhat quickly, just so that I can make sure that we can then open it up for questions and conversation. I put together this, a version of this PowerPoint shortly after March 25th, when EEOC issued its bipartisan regulations as a means of training EEOC investigators and lawyers. And then I've just somewhat modified it as I've gone along. Okay, so the first is, the purpose of the regulations is to implement Title I of the ADA, right? That's what we say in the beginning of the regulations. And the reason we do it is because everything starts with Congress. You know, after the regulations got issued, people would say, oh, the agency did this and the agency did that. And it's like, you know what? We didn't do anything other than what we are obliged to do as a commission, which is to implement what Congress has passed. And Congress passed a bipartisan, hugely bipartisan ADA Amendments Act of 2008. So our goal was to carry out what Congress was trying to do. And what Congress said all the way through the legislative history of that 2008 Act was that it wanted to stop what had become these mini trials on whether a person actually had a disability. Did their disability, did their impairment substantially limit them enough in some major life activity? And that's all that the courts were doing instead of getting to the merits of the case. So that's what Congress said it wanted to stop. And so this is what Congress said in its purposes act of the statute. And we in the agency repeated that in the regulations. Congress said the primary object of attention in cases brought under the ADA should be whether covered entities have complied with their obligations and whether discrimination has occurred, not whether the individual meets the definition of disability. They went on to say, and we repeated, the question of whether an individual meets the definition of disability under this part should not demand extensive analysis. Okay, so that was the goal. The analysis should not be extensive so that we can quickly get to the merits of the case. Were you really discriminated against because you have a disability or because you were a really bad worker, you know, or did you need an accommodation and you didn't get it? Those are the merits of the case. Okay, so that was their goal. Now, if you look at the definition of disability under the ADA as amended, the first 2 prongs look exactly like they were written before. Disability means a physical or mental impairment that substantially limits one or more major life activities of the individual, what we in the regulations call the actual disability prong, or a record of such an impairment. Okay, so that's the definition of the first 2 prongs of the definition of disability in the ADA as amended. So one can ask, how did Congress achieve its goal? Right? It's used the exact same words that were in the statute before that had apparently caused all of these problems. Now, here's how Congress did it. They added major bodily functions to the definition of major life activities, and they provided a set of rules for how to interpret the term substantially limits. Okay, so for the first two prongs of disability, the first two definitions, it's the same words, but very, very different outcomes in terms of who's covered. And that's what I hope to have you understand over the next, 10 minutes in terms of the first two prongs. So the first two prongs that I'm talking about are the prongs of disability where someone has to meet one of those two prongs to get a reasonable accommodation. So everything that I'm talking about is going to be for folks who are looking for a reasonable accommodation. What I hope to explain is how, even though it's the exact same words, very different outcomes, much easier, more streamlined, quicker analysis. So for all of you folks who are dealing with disability claims, this first threshold issue, do you have a disability, should be much quicker. That was Congress's goal, and mostly what we did in the regulations is explain how Congress's goal is achieved. Okay, so what we do is we follow the lead of Congress. We emphasize the addition of major bodily functions within major life activity. We pull out of the legislative purposes, findings, history, 9 rules of construction that Congress created for how do you interpret the term substantially limits. And then we explain how these work together, major bodily functions and these rules, to create the result that Congress wanted, which is this easier, more streamlined analysis resulting in more people being covered. You'll see that I talk about 1 + 1 + 1 = 3, that the adding major bodily functions and 2 of these rules of construction, the 2 most important ones, add up to this more streamlined analysis. That's what the agency did in the regulations. We took what Congress said it wanted to do, and we just made it more clear. Okay, some things are the same. You have to have a physical or mental impairment that substantially limits a major life activity. Physical impairment is just the way it was before. It's completely broad. It's any physiological disorder or condition. Mental impairment, also, same thing, completely broad. Any mental or psychological disorder. The physical or mental impairment has to substantially limit a major life activity. Some things are also still the same in terms of major life activities. Basically, what Congress did was take some of the EOC the regulation where we had defined major life activities, put it into the statute. The regulations, again, just repeat those, added a few others, but these are the types of major life activities you should be used to. Caring for yourself, seeing, hearing, eating, sleeping. We added performing manual tasks. But this is the sort of ordinary way of figuring out, does an impairment substantially limit a major life activity? I do not expect that these major life activities are going to be used in many situations. Like I said, the biggest change was adding major bodily functions. We think that's where people are going to go to first because it's going to be a much easier analysis. But these life activities still exist, and in some situations, people will be using it. But here's the key change. Major life activities include but are not limited to the operation of a major bodily function. And basically, this is every function in the body. That was the goal of Congress when it added major bodily functions. They made it clear by saying it's included but not limited to, and we just repeat this. Okay, so the immune system, special sense organs like seeing, hearing, normal cell growth, which becomes very important for cancer, digestive, genitourinary, bowel, bladder, basically any bodily function. Okay, so this physical and mental impairment has to substantially limit any major bodily function. Okay, so therefore the key question is, what does it mean to substantially limit, right? Because it's now going to substantially limit any major bodily function. These are these 9 rules of construction. They're the rules that Congress adopted to make it easier to establish coverage. And here's the kicker, guys, but we've all seen how Washington works. None of these rules say what substantially limits means, okay? It only tells us what it doesn't mean. Because remember, this was a deal between the business community and the disability community. And the business community needed to have those words again, substantially limits, major life activity. and they couldn't get a complete agreement on what it should mean. There was agreement on what it shouldn't mean, which is it wasn't this high standard that the Supreme Court had created, working off of the EEOC regulations. The EEOC regulations in 1991 is the thing that started this ball rolling by defining substantially limits as prevents or severely restricts, and then courts just ran with it. So basically, you'll see the rules of construction tell us what substantially limits is not. So, for example, it's to be construed broadly, not meant to be a demanding standard, because the Supreme Court had said it's a demanding standard. Does not need to prevent or severely restrict a major life activity, because that had been used by courts to kick a lot of people out. The third rule is what I call the aspiration as opposed to a rule, right, which is the primary, you saw this already, primary object of attention is whether discrimination occurred, so we shouldn't be having extensive analysis at this stage of whether it substantially limits. An individualized assessment remains. There was a lot of question about, is there still an individualized assessment, from the proposed rules to the final? Of course there is. You still have to show physical and mental impairment substantially limits a major life activity. You still have to do what I call add 1 + 1 + 1. It's going to be a lot quicker and a lot easier, and it will always add up to 3. And people will be covered. Okay, but you still have to sort of do that process. Scientific, medical, statistical evidence, you'll see, is not going to be needed often. I mean, it doesn't mean you can't put it forward if a person wants to, but based on the analysis, you shouldn't need it. And an impairment has to substantially limit only one major life activity, not more than one. Because courts were saying, oh, well, you have trouble eating or sleeping, but you can drive, so you're not disabled. Okay, so here, it's as soon as one major bodily function is substantially limited, that's it, you're done. Now, you could still say, reading all of these, I'm still not quite sure how it's so much easier. Like, you've told me what it's not, but I'm not sure how we're getting to this quicker, easier analysis. Okay, here are the 2 critical rules that add, when you add it to major bodily functions, these are the 2 that will make the analysis easier for many people, not everyone, but many. 1, you look at whether an impairment substantially limits that major bodily function or the activity without regard to the ameliorative effect of mitigating measures. So you look at the impact without the effect of the mitigating measures. And an impairment that is episodic or in remission, you look at whether it would substantially limit that major bodily function when active. Okay, so major bodily function plus don't take into account mitigating measures plus look at it in its active state. That's the 1 + 1 + 1 will equal 3 for lots and lots of impairments. So on the mitigating measures is basically anything that a person is doing to counter the impact of their impairment. So the most common one is medication. But there are lots of others, all listed here, including the sort of behavioral modifications. A lot of, for folks with autism, they'll have a behavioral modification that they'll do in order to counter the effect of their impairment. So the point is, you don't take into account anything that mitigates the impact. And with regard to medication, which, as I said, is going to be the main one, the focus is on how the major bodily function would be impacted if medication was stopped or if medication was never taken in the first place. So, for example, someone who has a diagnosis of cancer, the question is, absent treatment, absent medication, would it substantially limit normal cell growth? Answer, yes. Someone who gets the diagnosis of HIV infection, it's not the question of in that moment, how bad is their immune system? It's if they didn't take medication, would their immune system be substantially limited? Answer, yes. Okay? Now, there's an exception on mitigating measures, okay? The eyeglasses itself is the one mitigating measure that can be taken into account, okay? So, for example, without my eyeglasses, I just see a lot of pretty colors, and now I see pretty people, okay? But, so without the mitigating measure, I would be substantially limited in seeing, but as part of the deal, just because you wear eyeglasses doesn't make you a person with a disability under the first or second prong. However, to deal with the case, which had generated a lot of this bad case law, the Sutton sisters, it makes it clear that if an employer for some reason has a qualification standard that says you can only get this job if you have uncorrected perfect vision, so we're not hiring Feldblum or anyone else out there with glasses or contact lenses, the employer has to justify that qualification standard as job-related and consistent with business necessity. And if they can, awesome. And if they can't, you got to get rid of that qualification standard. Okay, so that's the 1 + 1 + 1 = 3. You add these three elements together. Some impairments will virtually always be disabilities. And so what we did in the regulation is, after listing these rules of construction, we created a section called predictable assessments. It's called the J31, predictable assessments. And this is a long way of saying 1 + 1 + 1 = 3, okay? The principles are intended to provide for more generous coverage through a framework that is predictable, consistent, and workable, right? And we then said, for example, applying these 9 rules of construction, the individualized assessment, because you do have to sort of do the addition, the individualized assessment of some types of impairments will, in virtually all cases, result in a determination of coverage. Why? Given their inherent nature, okay, just given the medical facts of if you don't have treatment and you look at something in its active state, okay, these types of impairments will, as a factual matter, virtually always be found to impose a substantial limitation, and therefore the assessment should be particularly simple and straightforward. This is what I call the virtually always group. It's the J32 group, okay? We did not, as an agency, try to come up with the entire DSM-4 list of the types of impairments that will virtually always end up being covered. But again, it's just conceptually, you can see there are any number of impairments that will very easily be covered, and you don't have to do get a lot of medical analysis. Okay? And then to make it even easier, besides the J32 virtually always group, there's the JC33 group. That is, what we did is we did the analysis for you for a bunch of impairments. Like we did the 1 + 1 + 1 = 3. To say, look, applying these, it should easily be concluded that the following types of impairments will, at a minimum, substantially limit the major life activities indicated. It's like sort of giving the way to do it, and then you can see, is something like something else on this list? Okay, so the J33 list, again, it's not a quote-unquote per se list because you had to add 1 + 1 + 1 = 3. What we did is we added it for you. So it's only if there's some bizarre, weird thing, like, for example, cancer is on this list. The only thing we could figure out in terms of negotiations on this reg would be if you had a type of skin cancer that affected only 3 cells, and even if you didn't take any medication ever, it would only stay 3 cells. Okay, if there was such a type of cancer, then even though cancer is on the list, that type of skin cancer wouldn't be covered. Okay, but I haven't heard of that yet, but okay, so here's the thing. So some of them are like very, these weren't folks who had issues before, deaf, blind, intellectual disability, or not, some of them didn't. Here are the way, these folks are covered because it substantially limits this particular bodily function. But then this is the list of people who had difficulties. So you've got autism, cancer, cerebral palsy, diabetes, epilepsy. What we're saying is they substantially limit this particular function. And so again, it doesn't matter, diabetes, you can have more mild to more severe diabetes, but what we're saying is that when you don't take into account medication and you look at it in its active state, the fact that you got the diagnosis of diabetes means it will substantially limit your endocrine function. Okay, so it's not like the person still has to have the medical diagnosis. I have diabetes. But then that's it. After that, then you move to what's the accommodation you need? Or thank you for sharing. I know you have diabetes. That's not why I fired you. That's not why you didn't get to go to this conference. Okay, but it's sort of like you don't spend a lot of time. Are you really black? Are you really white? Are you really Jewish? No, you're like, you did not go to this conference because you're Jewish. So for a lot of these folks, it's going to be covered, and then you move to the merits. Did discrimination happen? Okay, so here are some examples in terms of physical impairments. And there will be others that are not listed, but are like in the virtually always, that would fit the same way. And here are some examples of mental impairments. So major depressive disorder, bipolar, PTSD, OCD. So again, the more significant mental disabilities. Okay, last rule of construction, and this one is different from what had existed in the EOC regulations before. An impairment that's temporary, right, might last less than 6 months, can be substantially limiting. Now, what happened is Congress passed the ADA in 1990, said physical and mental impairment substantially limits major life activity. EEOC in 1991, in their regulations, just came up with a rule that to be substantially limiting, you had to be of a certain duration. The impairment had to be of a certain duration. That was never in the statute. EEOC just came up with it. So in the ADA Amendments Act, Congress made clear that, no, something could be temporary and substantially limiting. And for example, a broken leg is a great example. It will heal, but for that period of time, you can't get more substantially limiting of the musculoskeletal system. Okay? Now, it also means that the accommodation that you ask for that is also going to be time limited. Okay? Remember, all of this stuff is only you're dealing with if the person's asking for an accommodation. Okay, so that's rule of construction 9. Now, so this is, up till here is hopefully how to explain how Congress achieved the goal of a much quicker sort of nanosecond analysis of do you have a disability? Because lots of disabilities will in fact, once you don't take into account mitigating measures and look at it in its active state, will, be covered. But there are some impairments that will be on the spectrum. For example, I have fibromyalgia. It hasn't flared up in 15 years. Okay, fibromyalgia, and yet for someone else who has fibromyalgia, it's absolutely quite limiting. Okay, so there are some impairments that literally are on a spectrum. Just getting the diagnosis is not enough. So there will be some groups, and a lot of the back impairments and stuff like that is going to be in this category. Okay. They will be on a spectrum. For those impairments, the final regulations add back in the condition, manner, or duration framework. Okay? You can consider, for example, the difficulty, effort, or time required to perform a major life activity. For these, you're also more likely, I think, to find the old major life activities, walking, bending, lifting, right, performing manual tasks. So the difficulty, the pain, the length of time, all of this stuff will come into play. The focus on all of this is going to be how the major life activity is limited, not on what outcomes the person can achieve. This is particularly important for people with learning disabilities who would often get kicked out of court because they were in medical school. So how could you say you were substantially limited in learning? Well, no, but it's how they learned was different. Okay, and so you don't look at the outcome, you look at how you're doing the activity. Is that different? Okay, so condition, manner, duration is going to be important for some group of folks with impairments, but it's not going to be the norm. Okay, it's not, and that's, we made it very clear in the final regulations, you don't have to use condition, manner, duration for some impairments. For example, the ones we already did the analysis for you under J33. But it's out there for those impairments that will be on the spectrum. Last thing in terms of prong 1, there'd been a lot of focus on whether you're substantially limited in the major life activity of working. That is, a lot of courts would say to someone, well, you can't do this, but you say you can work, so you're not disabled. Okay? So the final regulations made it clear that the major life activity of working is something that you really only use as a last resort if you're not limited in some other major bodily function. We did that partly by moving it out of the regulations and into the appendix. Okay? And then second, make clear what we had said before, that to be limited in working, you have to be limited in more than just one job. Okay? Can't just be limited in one unique job. I don't like my supervisor, therefore I'm limited in working. Okay? It has to be a class of jobs, a range of jobs. But then gave an example that it can be the nature of the work or, more importantly, job-related requirements. So this is going to be important for essentially more lower-income folks doing manual labor. So the most important part is the last one. Let's say you have someone who can lift 20 pounds, even 30, even 40 pounds, but can't lift 50 pounds. Okay, so that person may not be substantially limited in lifting, because it may not be easy for most people to lift 50 pounds. They may not even be substantially limited in their musculoskeletal system. That might not be easy to show. But they are substantially limited in the class of jobs that require heavy lifting. Okay, so that person, even though that person doesn't look as if he or she is disabled, that person is substantially limited in the class of jobs requiring heavy lifting. And again, what this is going to be important for is reasonable accommodation. All that this gets the person, once you're covered under the first prong, is the ability to ask for an accommodation to perform the essential functions of the job. So if heavy lifting is part of the job, what the person is potentially asking for is an accommodation to be able, some device that will help them lift the 50 pounds, or a different way of moving things that lets them achieve the goal of the job, even with this limitation. So it's an important protection, but for a very focused, limited group of individuals. Okay, all that was prong one. Prong two is basically just like prong one, except that it's the record of an impairment as applied by these principles. The main thing is that prong two also, you can get a reasonable accommodation, and both for folks who are limited in working or in a lot of the others, the main new accommodation that I think a lot of folks are going to be asking for are changes in schedule and leave. And again, this is something within the federal government, people already had access to annual leave and leave issues, so it's going to be much more of a new big thing for the private sector that often didn't have job-protected sick leave or other time off leave. Okay, so, but what it does mean, and this brown bag is not on reasonable accommodation per se, I'm sure we can have a follow-up one. This is just about the coverage issue first, but it will mean that all the issues that many of you have been dealing with about leave as a reasonable accommodation in the federal government, because you guys have been doing it a lot more than the private sector, is just going to be, in fact, that much more important, and that much more important to be doing it correctly. And correctly doesn't always mean that the person gets all the leave they want, because there is an undue hardship limitation. But important to know that the accommodation that people under the record of prong are most likely to be asking for are going to be leave or schedule changes to do follow-up. Okay, all that is prongs 1 and 2. Okay, that's where you're going to be, folks are going to be looking at if they want a reasonable accommodation. The other main change that Congress did, and this change was actually changes in the words of this statute, was under prong 3. And prong 3 is now an incredibly broad protection. It is going to be a real challenge. I mean, personally, I think it made sense that Congress did what it did. I think it is important protection. But it's going to create a really critical management challenge. That is, everything that, and maybe again, you know this already from the federal government, that, I mean, everyone has a race, everyone has a sex. So, I mean, the Office of Federal Operations knows I spent 3 months reading every single case that came through that mentioned gender. And I used to say before that white Christian men didn't know they were covered under Title VII. Well, I will never say that anymore, because in the federal government, certainly in the Postal Service, every white Christian man knows he's covered. And if he hasn't gotten to training or hasn't got, you know. So, but the thing that you're about to see is that under prong 3, any person with an impairment is going to be covered if they can allege that the reason they were discriminated against is because of the impairment. Okay, no substantially limits, no major life activity attached. So I would just use this as a clarion call to managers about needing to, in fact, document when people are performing well or not well, because people can allege discrimination now under this third prong. Again, I think it is important protection for when people really are discriminated against because of an impairment. And now they don't have to jump through any hoops of substantially limits or major life activity. So it's important to understand the breadth, understand the management challenge that accompanies it, and then hopefully have it be used to protect the people it was designed to protect. Okay, so here's what Congress did. They kept being regarded as having such an impairment. That's the third prong. And then they said, as described in the statute, it was Section 3, in the regulations, it's paragraph L. And what that means, we just brought paragraph L up into the definition. This means that the individual has been subjected to an action prohibited by the ADA as amended because of an actual or perceived impairment that is not both transitory and minor. Okay, that's what the statute says. So, the third prong is going to be used when reasonable accommodation is not at issue, because if you need reasonable accommodation, you've got to be under prongs 1 or 2. The key thing is action, right? If the covered entity takes an action prohibited by the ADA on the basis of the impairment, so long as that impairment is not both transitory and minor, that action establishes coverage under the third prong. Okay, so it's a completely circular protection. The act of discrimination on the basis of an impairment transforms that impairment into a disability under the third prong. Okay, so even though it's still called the regarded as prong, there's ordinarily no need to get into the perception. So the whole thing of like, did the employer think you was substantially limited? All that is gone, has been wiped away by that congressional change. Okay, the only time perception is going to even be relevant in the third prong is if the person says, I was perceived as having an impairment. Like someone got discriminated against someone who was gay because they thought she had AIDS or he had AIDS, you know. But generally, that's not what's important. What's important is, can the person show there was a causation between the act and the impairment? The only impairments that are excluded are ones that are both transitory and minor. So the only time transitory, right, 6 months or less shows up in the statute is now on the third prong. If an impairment is both transitory and minor, then they're not under this broad coverage. Okay, so a broken leg obviously is still covered because it might be less than 6 months, but it sure as hell isn't minor. Some very minor asthma, you know, that may be quite minor, but it's going to be chronic, that's not excluded. Okay, so only impairments that are both transitory and minor are excluded. There has to be a prohibited action, but that's just any action that you take in employment. Okay, this is the same general list. And the key thing is there has to be causation. Okay, the key thing is the individual has to show some evidence that that action was taken because of the impairment. And the remedy, again, it's never reasonable accommodation. So they're saying, I didn't get hired, I was fired because of the impairment. Now, just establishing coverage doesn't mean that you've established liability. Right? Someone might say, yes, I didn't hire you because you were blind, absolutely, and you were applying to be a bus driver. So you were covered under the third prong, but because it established it. You also covered under the first prong because being blind, you're substantially limited in seeing. But just because you're covered doesn't mean that there is liability. Okay? But it does mean that if the person took the action based on your impairment and they can't show it was because you were not qualified, you're covered regardless of this substantially limits a major life activity. And one thing, and I realize I just took a slide out to make it shorter, but one thing that was unfortunate that I think stayed in, but we have it here. Exclusion for failure to meet a qualification standard, that uses the third prong definition of disability. So this is why this is important. If an employer, a business, an agency has a qualification standard, like you have to be able to stand for 8 hours, or you have to be able to work under these types of temperature conditions, okay? Any qualification standard, if that standard would screen out people with a disability, and it's the third prong definition, so if it would screen out people with any physical or mental impairment that's not both transitory and minor, the agency, the employer, has to justify that qualification standard as job-related and consistent with business necessity. Okay? So for things like back impairments, right, there are lots of these rules that will screen people out. So it creates this initial burden on the agency to go through their qualification standards and just make sure, are they job-related and consistent with business necessity? So when I was talking to folks in the hotel industry on this, a good example is for bartender, right? You might have a rule that says you have to be able to stand for 8 hours. They very well might be able to show that's job-related and consistent with business necessity. So the qualification standard is valid. If someone then wants an accommodation, like they want to have a stool, okay, that person does have to come in under prongs 1 or 2, really prong 1. Right? So their back impairment has to rise to the level that it substantially limits their musculoskeletal system. But again, a much easier standard now. And then they can get that accommodation as long as they can still be performing the job up to par with that accommodation, and that accommodation isn't an undue hardship. So this is a little bit of a sleeper, this qualification standards piece. I've been trying to unsleep it as I've been out there talking to folks, both plaintiffs and employers. This is your moment to go back, check your job descriptions, check your qualification standards. Are you inadvertently screening out people with impairments when it's not job-related and consistent with business necessity? So do that first. Then after that, even if it is, someone might in fact be able to ask for an accommodation in order to be able to meet the overall purpose of the job. Like the purpose of being a bartender is to serve drinks, not just to stand for 8 hours. Okay. The overall regulations, takeaways, and then we will open for questions. Congress wanted to stop the focus on coverage of disability by the courts and to get courts to move more quickly to the merits of the case. Ooh, someone's phone is getting louder. Okay. When reasonable accommodation is at issue, prongs 1 and 2 will apply. The combination of 3 changes is going to make it easier to achieve that coverage and more predictable. And that's your major bodily functions, don't take into account mitigating measures, episodic and in-remission impairments looked at in their active states. Given those changes, there are a number of impairments that will virtually always be disabilities. That's your J3-2 category, virtually always. And the final regulations provides examples of impairments that should easily be concluded to be disabilities. That's your J3-3 list. For impairments not in the predictable assessments category, not in this virtually always, condition, manner, duration will be relevant. The fact that substantially limits is lower will often be important. I used to write there, important if not particularly illuminating, but then I took that off. It's just, it is a lower standard, even if we haven't told you exactly what it is. And people will be covered under working only when they really need to be in that category. The impairment-only standard of the third prong achieves the goal of getting to the merits of the case very quickly because all impairments are covered other than those transitory and minor, and the key issue is precisely whether the prohibited employment action happened because of. So it just gets to that merits of because of right in the beginning of the case. But obviously the breadth of the third prong will require good management skills because you want to make sure you've got documentation if some adverse action has been taken against that person, that you've got documentation that it's not because of some impairment. Employers, agencies, federal government should all be focusing now on qualification and reasonable accommodation, hitting the refresh button on reasonable accommodation procedures, and we as an agency need to make sure we're giving you good guidance, especially, as I say, I think on some of the leave and scheduling issues. Some links, and here, I know none of you look like that kid anymore, but that's the best I could find. And you get to now ask your questions instead of sending them to me at that, but you can also send it to me at that email address. So, okay, questions.
Before I turn it over to the audience, I'm going to take the host prerogative to ask the first question. Mm-hmm. I've gotten this question quite a bit in training. I think it frustrates a lot of people. EEOC is seen as doing something of a dance with semantics when we call things virtually always as opposed to just saying it is a disability. So maybe you could talk about why we did that in the regs.
Oh, well, it starts with the first thing. We can only implement what Congress passed. Okay, Congress had before it, and one of the deals that ended up not working at the end because both the disability and business communities didn't like it for different reasons, was the statute from the state of Maine that simply had a whole list of impairments that were listed. That's called a per se list. I mean, if Congress had done that, we would have done the same thing. But Congress didn't. And that's because of the way that negotiations happen. So instead, Congress was trying to get to that same goal, that same point. When they dropped that list of per se impairments, that's when they added major bodily functions. And literally, the point of adding major bodily functions was to try to get all of those impairments that were on that list essentially easily covered. So that's what they did. We can't do anything about that. All we can do is clarify this is what Congress was trying to do. It was trying to make it very easy to have those folks be covered. But it was an important point in the negotiation and in the negotiation inside this building. I mean, this is a bipartisan regulation to say there's still an individualized assessment. You know, you still have to add 1 + 1 + 1 = 3. And so that's not our, I mean, it's funny, someone asked me whether I liked doing policy, you know, as a commissioner, and I was like, well, you know, when I was outside as a law professor and a legislative advocate, when I was working in some of these bills, I had much more latitude, because it could be, well, what do I think it should be? Not when I'm a commissioner. When I'm a commissioner, it's what did Congress pass, and how do we implement that? So.
All right, so let's open it up for questions. And I didn't say this in the beginning as part of the introduction, but you have the opportunity to ask questions of someone who refers to herself as the mother of the ADA.
No, I never do. Other people do that.
Other people.
Oh, no, I do say this. I say that I don't have kids. You're right. I do it that way. I always say I don't have kids, I have laws. You know, like instead of it's a boy, it's a girl, it's a law. And it is true. That is true. I just never think about it. I always think about it as I have a kid. As opposed to, because when you say your mother of, like, people feel like, no, but I'm the person, I did this. As opposed to, I figure, it's my kid, and that kid could have lots of other parents.
There are lots of people in the EEOC who say they are the mother, but you are
yeah.
the opportunity to talk to someone who's an expert, so
yes.
Here's your chance.
On both the original ADA, because I started it in 1988, and then also in the ADA Amendments Act, I was very active in these negotiations. Yes, right over there.
Hi, my name's Jay.
Uh-huh.
As I read the regulations and try to remember some of the language that I've seen, particularly as it relates to prong 3 and reasonable accommodation. So I'm going to try to pull it together as how I
Okay, but let me stop you right there, because if you're under prong 3, you don't get access to reasonable
Well, the
accommodation.
language speaks to you're not entitled.
Correct.
So if you're not entitled, that kind of suggests that the agency in good faith or being a good employer can still provide reasonable accommodation in the instance that you're a person that falls under prong 3. And so I want some clarity around that, because it's kind of confusing at best when it says you're not entitled, but when otherwise it speaks to, well, you are entitled. So entitlement versus not entitled.
Okay, well, number one, just because you're entitled to reasonable accommodation only if you meet the other aspects of reasonable accommodation. That is, you have to, with that accommodation, be performing the job up to par, and that accommodation can't be imposing an undue hardship. So no one's entitled to just whatever they want. It's the statute provides an obligation on the agency, if someone is under prongs 1 or 2, to in fact go through this reasonable accommodation process. Okay? If someone wants a reasonable accommodation, they have to demonstrate, for statute, I mean, an agency can do whatever it wants out of the goodness of its heart, okay? But in terms of the statutory obligation, maybe the best way to think about it is this: there is no statutory obligation for an agency to provide an accommodation to every person who has a physical or mental impairment that's not transitory and minor. There's no obligation, no statutory obligation to provide an accommodation to someone who has just any physical or mental impairment, that's not transitory and minor. There is a statutory obligation to provide a reasonable accommodation that enables the person to do the job or to benefit from the goods or privileges of a job, so long as that doesn't impose an undue hardship. That is the obligation, and that obligation now extends to many, many more people than you had thought of before. Okay? So essentially, the first question when someone says, I want an accommodation, should not be, well, let me now spend an hour on whether they're a person with a disability. Okay, the first question is, well, what are you needing this accommodation for? Let me know the diagnosis. And that's like 2 minutes. And then you move to, number one, and here are your 3 most important things about accommodation. Just because someone wants something because it would make life easier doesn't make that accommodation. An accommodation has to be necessary for the person to be able to perform the job or enjoy the privileges of a job. Okay, it's not just something, it would be nice. They have to make the connection to, no, I need this in order to basically be on a level playing field with everyone else. Okay, so that's number one, and that's their obligation to show. And number two, the second is, once they get that accommodation, whatever it is, are they now performing up to par? Okay, accommodation is not code word for mediocre work or whatever the standard is at which you can fire someone. Maybe it's not mediocre, maybe it's lower than that, but whatever. And then accommodation just allows you to perform at the level that everyone else is required to perform. And third, if the accommodation is going to be an undue hardship, and that's not just financial hardship, it's logistical, practical, operational hardship. Okay, if it would be an undue hardship, then that's not required. Okay, so reasonable, that's why I say at the end, you got to hit the refresh button on the reasonable accommodation procedures. There are lots of people out there in the federal government, from what can I see in terms of reading, who are not getting the accommodations they deserve and they need to perform because people are not engaging with them correctly. And then there are lots of people who think they're entitled to things that they're not. Okay, so the refresh button goes both ways, because it doesn't help the people who really need and deserve accommodations when other people are demanding accommodations that, in fact, the statute doesn't say they should be getting.
I have another question.
Uh-huh.
It's me back here.
Yeah, I know.
And then I'll come to you. Can we talk about the broken leg example?
Uh-huh.
Because this is an example that we, previous to the Amendments Act, used regularly as an example of a person who does not have a disability. But that is notably absent from our regs or the appendix. So what about the broken leg?
Right. So you do have to know that the lawyers in our Office of Legal Counsel blanched when I said to them, by the way, broken legs are covered. And they're like, but we always say they're not. And I'm like, well, stop saying that. Okay, so here's the thing. If you've got a broken leg and you're not asking for an accommodation, okay, no one should be fired because they have a broken leg. Now, the bottom line is not many people are fired because they have broken legs, or for that matter, asthma or other stuff, other than the sick leave issue, which is, again, not an issue in the federal government. But for the private sector, for low-income folks, for folks who have been working for employers with less than 50 employees, so they have not been covered by the FMLA, this is a game changer for them in terms of job protection. And then it's important if they have a broken leg. Now, so that's now an accommodation. So now, let's say, so if you need an accommodation because you have a broken leg, you need an accommodation. It's like you need that, either you need the accommodation of being able to now get into your workplace. So let's say it's a type of job where you could do your work with the broken leg, but you need an accommodation in terms of access. That's what the law now says. You are substantially limited in your musculoskeletal system. Maybe what you need is a parking spot closer to the building. Right? That's the accommodation. That's what's going to enable you to continue working. The whole point of the ADA is to allow people with disabilities to work. right? So for that person with the broken leg, they need that parking spot for those 4 weeks. Now, the difference is that once their leg is healed, they got to give up the parking spot. Right? The accommodation lasts only as long as the impairment that's substantially limiting the musculoskeletal system works. Okay. Again, it's going to be an issue, I think, less in the federal sector than in the private sector. For this, someone could have a broken leg. Let's say they needed to go to the doctor, and if some employer didn't want to deal with them, they'd say, you're fired. There was no law against that because the EOC had said broken legs were not. Well, but there was no law. Now, if they at least get the accommodation. Now, and there should not be an undue hardship with letting someone go to the doctor. There may be an undue hardship in having the person be out for 3 weeks. Okay, so the private sector is now going to be dealing with these issues of accommodation in a way that they hadn't before. But because leave as a reasonable accommodation is going to be one of the more complicated issues, something that Commissioner Lipnick, my Republican colleague, whom I negotiated a lot of this regulation with, and I are both very concerned that the private sector and the public sector understand. We had a commission hearing on leave as a reasonable accommodation. I encourage you to go to the website and listen to that. Lots of interesting information. And we are working on a document called Leave as a Reasonable Accommodation, so that there's guidance that makes it, if not clear, because undue hardship by definition is individualized assessment. So it's not like we're going to be able to give bright line rules, but we'll be able to give parameters.
My question is about, you said earlier about enjoy the privileges and
Benefits of employment.
And benefits of employment, as well as the first prong of being able to meet the
Right.
requirements of the job. What about intangibles? So there's been case law about someone saying I need a sink lowered so I don't have to go, and then there's
Dignitary harm and this.
and
Yeah.
yeah, exactly. So dignitary harms, especially considering you could conceive of
Yeah.
that as part of a privilege
Well,
of a job.
this is a good thing why you should come back to the brown bag lunch on reasonable accommodation. Okay, this was the brown bag lunch on, although no one's eating other than, well, some people are. Anyway, at the next one, definitely feel free to bring your food. I think on reasonable accommodation, there are going to be lots of issues and questions. And so since we are at this stage inside the commission, just looking at, we're pulling up our 2002 guidance on reasonable accommodation. I would certainly encourage you to take a look at that. We're going to be doing a nice little summary of the reasonable accommodation cases within the federal sector. I know, I'm sure Ernie Hadley has his great, wonderful treatise, so we're looking at his chapter 14, which is ADA and reasonable accommodation, to see what we can pull out. So until we end up doing that and having a little negotiation inside the commission, I don't want to answer specific questions, but I'm very happy to get questions. You should still use this to email me your tough reasonable accommodation questions, because I would like to be having them as we are trying to revise this guidance.
So, before, I would get cases of women who are pregnant, and that causes a certain medical condition, and I would have to maybe turn them away because it was temporary.
Right.
Am I to assume that now, just like the broken leg, it would be different?
So here's the thing about pregnancy. Remember I said some things are still the same. It has to be a physical impairment. And so what we have said in the regulations, and we repeated it in this one, is that pregnancy itself, a quote-unquote normal pregnancy itself, is not a physical impairment. So someone who, because of a normal pregnancy, ultimately can't lift a certain amount, that person is not going to be able to ask for accommodation because there's not the impairment. However, if the pregnancy has given rise to some medical impairment, and often that is the case, then that person can be covered. Absolutely. The fact that it's temporary is not a, you're out and done. And instead, it's, is that an impairment? What major bodily function is that impairment substantially limiting? Again, for a lot of folks, it might be the lifting. And what they get is at least some accommodation. It might be they don't have to do some part of their job for that period of time. Yeah, follow up. Wait for the mic. Yeah.
What about, and I know I'm being specific, but like a female who has to be on bed rest,
Right.
could they ask for work at home if they just can't,
Yeah.
through doctor's orders,
Right.
be at work, but
Yeah.
could still do the work?
Right. So I need to, that then becomes the medical question. You know, I mean, most people who are pregnant don't have to be on bed rest all the way to the end. So it feels to me like there should be a medical reason. But see, that's where you would have to have at least enough of that medical information to bring it out of normal pregnancy and into some impairment world. But once you do, then yes, I think you can ask for that. But it's, you know, I'm sure that's, so I just want to say that's the framework. Whether in fact that's going to be held to substantially limit, I don't know. You know, I think that's going to be one of the tougher situations. But yeah.
Just to follow up on that, this was a scenario that happened a few years ago. Our agency, I just want to see.
You might want to talk closer into the
I'm
mic.
sorry, can you hear me? If you have a person in the office who's pregnant, who hasn't asked for an accommodation, but let's say it's getting to be far along, there are males in the office who notice part of her job is lifting boxes and things like that. They, without consulting anyone, offer their help. Does that then put her under prong 3 if she were to say, now I want an accommodation because I'm pregnant?
No,
Or
not
you
at
were
all.
cautioned about that a few years ago that,
I
that
see.
you shouldn't assume someone, you know, that
Well,
was
what's true, and this has nothing to do with the law, this is just generally men should do this before they start doing things for women. They should ask, do you want us to do that? Okay? So, but that's a gender issue. But that's the fact that you've now, I mean, I think that's a great idea for the guys in the audience, the guys in the workplace to say, do you want me to lift it? Because now the third, people used to say, don't ask about if they have this because then they'll be covered under the third prong. Don't do this because that was all a concern when it was all about perception. How are you perceiving the person? Perception is gone. Okay? What matters is, did you take an adverse employment action? That's all. So because the thing is, you can't engage with someone to make sure they can be doing the job well if you don't talk to them about, hey, you're not doing the job well. Is there something you want to tell me? Okay, so, and people were not doing that because then afterwards she'll say, you can now do that. You know, I mean, again, you can't do medical exams. You can't say, you know, fill out this medical questionnaire. You can't do probing medical questions unless they're job related. But you can say, you are not performing up to par. You need to be over the next 3 weeks. And then what you want is to have a good reasonable accommodation process set up in your agency so you say, if the reason you're having trouble is because of an impairment, you don't need to talk to me, your direct supervisor. You can call this person, your reasonable accommodation manager. Go talk to them. Now that person will have to come back round to me because you might work out some modification. I'm going to need to say whether that's an undue hardship. But then you don't need to tell me all the details of the medical situation. You know, you just need to tell that to someone else and then work out a possible accommodation. That person will come back and talk with me. You see, supervisors do not have to be involved in the medical details anymore. That's what you say. Lots of folks are covered. If someone says they have diabetes, MS, don't say, oh, well, my aunt had MS and she had no problem. It's like, you know what I mean? Because a lot of them do that, and a lot of them try to be their own medical doctors. It's like, nope. If someone comes to you with a medical issue and they want something, you send them over to the reasonable accommodation person. B, if someone doesn't come to you, but they're just not performing well, you go to them and say, you're not performing well. And if it's because of a medical situation, here's who you talk to. And that doesn't violate the law. It doesn't create coverage under the third prong. Okay? It just sets the things in motion the way it should happen.
I have a question.
Hold on. Oh, okay. So we'll do that one, and then you'll get the mic for the next. Yes.
Recognizing that the law stipulates that if you have a history of a disability or some type of medical issue, what impact, if any, do you foresee the advances in technology having an impact on the definition of disability, or do you see that at all?
Well, I think we will find lots and lots of people who have recovered from, right, or been helped in terms of their impairment. But I think a lot of these folks will still end up being considered under prong one, let's say, because it might just be in remission, right? And remember, impairments that are in remission are considered as if they're in their active state. So I think that will continue to have broad coverage. Again, once someone has recovered completely, usually there's not an accommodation that they need, other than sometimes an accommodation of a schedule change or doctor's visits. But I do actually think that in terms of technology, we're going to be having lots and lots of people with impairments in the workplace where they should be. And then the goal about this is to not have myths and stereotypes stop those people from being able to work and get a paycheck.
Well, one of the reasons I asked the question is because with the advances with, let's say, prosthetics, recognizing that, if you take your prosthetic off, you still have the disability, but in some arenas, and this is probably a question under reasonable accommodations, with the advances that they're making, they're, in some ways, they're saying that, hey, you do better walking than a person that has their legs,
right.
or has their arm.
Well, that's the importance of the rule that says you don't take into account mitigating measures. I mean, that's the key thing. So you just look at it without that technology, how, are they disabled? And then, but they may not need an accommodation, or they might. But yes, that's the importance of not taking into account mitigating measures.
Thank you.
Yeah.
I ended up having two questions. One is a follow-up to, in regards to managers. Basically, you stated as a given that there will be a reasonable accommodation person other than the supervisor. I am at a very, very large agency that still has in their policy that first-line supervisors are the decision makers for accommodation decisions. So, and I guess it's more of a rhetorical, when EEOC gets to the point of looking at the guidance and perhaps revising it, could it possibly be included in that guidance so that this first-line supervisor as decision maker policy is no longer good practice?
Yeah, and so here's what I would say about that. I definitely think that our guidance needs to be more clear about what it is that federal agencies need to have in place. I don't think the answer doesn't exclude the supervisor, because that's necessary for the undue hardship analysis. It's just, it can't be that the supervisor gets to decide. It's just, that is not a correct application of the law. Because A, the supervisor doesn't need to know all of that background medical stuff, And, I mean, it's not that the law prohibits it, but for the federal government, which is bigger, it has to be that you go to someone else, you basically have someone who knows about accommodations, who's then basically your person who's talking with the supervisor. It's like our Kendra here, Every agency should have a Kendra. Maybe we should end on that title. This is Kendra from EEOC's Reasonable Accommodation Manager and Disability Program Manager and other such titles. And I did just see, we're 10 minutes over. So do we have one last question? Go ahead. Oh, okay, it is, okay, then I'm okay. I mean, they'll live without me. Okay, go ahead.
And my second question, actually, going back to your sleeper hit of the qualification standards, in terms of determining whether or not qualification standards are inherently discriminatory, do you look at the standards for the job series or for the job as actually performed by the individual? For example, some of our mission critical occupations, the series has strict medical requirements across the board, but that series works in, I'll give it away, tower environments or in regional radar situations, which they don't actually need to look out the windows. They're going to be staring only at computer screens.
Right, no. It has to be, the qualification standard has to be to the job that you are then applying for. So if you have a qualification standard broadly, it might be job-related and consistent business necessity for some, in which case they'll be valid, but not for others. And it has to go to the job that the person is trying to get or perform.
Can I just
Yeah.
follow up on your first question and offer a piece of guidance to folks who experience this issue? Your agency is not the only agency that still leaves the decision in the hand of their first-line managers without the support of a disability program manager to help them make that decision. Until you all actually revamp your policies, which we obviously encourage you to do, you can take a look at our reasonable accommodation policy. And we tell agencies regularly, go to our website, look at our policies. You will see we do not leave it in the hands of our first-line supervisors, despite the fact that most of them actually know this area pretty well. So you can take that as a message that maybe that's not a fantastic idea.
Oh, no, why not?
Our guidance for the executive order, which was obviously written many, many years ago, says that it should be, the decision should be left in the lowest level of, so first line supervisors.
Okay, and that's for which executive order?
That's effective.
13164 on providing reasonable accommodation
Oh.
and writing procedures.
Okay, but I think we can work with that. In what I was saying before, I don't think we should be excluding because what you don't want is someone, 1,000 miles away saying, well, couldn't possibly do that. That would be an undue hardship, when they have no clue about how things are working on the ground level. So there's got to be a synergistic relationship between the supervisor, who has to deal with now fitting the accommodation into getting the work done, and someone outside of that person who can say, I'm sorry that that's a little bit more of a headache. A headache is not an undue hardship. So it's got to be a synergy of those two sort of places working together.
I had a question that goes back to, it's kind of a mixture of the broken leg and the, which would be under, the way we talked about it, under reasonable accommodation, and then the transitory minor, which is not for reasonable accommodation, but they're very similar, and there's a lot of confusion on that. So my first question is, when I train, I get questions on, well, what does minor mean? Because there's no definition. There's a definition of transitory, but they leave minor alone.
Right.
And then the connection or lack thereof when you're looking at, say, for that reasonable accommodation with the broken leg, where there's this connection of, well, it may be severe, which is the opposite of minor. So, and how you're supposed to look at that.
Okay, so I think the first thing I would say is, when you're thinking about reasonable accommodation, the words transitory and minor should never pass your lips. Okay? Just like when you are looking at something that's not asking for a reasonable accommodation, the word substantially limits and major life activity should never pass your lips. Okay? These are two completely separate worlds. Okay? I mean, it had to be in the negotiations that once physical or mental, once third prong became an impairment-only standard, any physical or mental impairment, so long as you could show a causation, you could bring a claim. So long as, once that deal was made, that act transformed an impairment into a disability, the business community required that the most minor, and we were talking cuts on your finger, a scratch on your face, okay? If something was both minor and temporary, and less than 6 months, then you weren't going to be allowed to use it to transform it into a disability. So in my slide, I just say minor means minor. It's plain meaning of the word. Look up minor in the dictionary, okay? It's minor. It's something that is trivial, okay? It's a cut on your face. It's, it's something really small and trivial. So something small and trivial and transitory, okay? Or even like a cold. I mean, cold doesn't feel so minor when you have it, but a cold would be also covered under minor, So minor and less than 6 months, that's what you're dealing with if someone is not asking for an accommodation and they're just coming forward and saying, I didn't get that promotion because I have asthma, okay? And like the most minor of asthma, let's say, okay? But I mean, I shouldn't say so minor. Asthma, so it's not minor, but and chronic, okay? So that's when you would be dealing with transitory and minor. I don't think you're going to be dealing with transitory and minor a lot, personally. okay? Because I think the bigger issues are the accommodation issues. So in accommodation, the word transitory minor just never appear, right? And instead the question is, what's the diagnosis? And is that diagnosis one that, in its active state, without mitigating measures, looks like some of these other ones that we have said are covered? Is that helpful?
Yes,
Follow up
it
on,
was.
yeah, what you
Although I
think you
guess-
would get as a follow-up.
Well, more on the even though you know you're not supposed to connect the transitory and minor to the substantial limitation, just sort of going back to the perhaps shock in this building that a broken leg would no longer be something that would be considered, and we used the word minor before.
Right.
And now we don't use that word, but it's severe enough so that you'd be substantially limiting, even if it was for a very short time. And just how that there was a decision, obvious decision in both of those cases, not to define minor and not to define exactly what that substantial limitation was going to be, other than give examples.
Right, right. And I guess, you know, part of it is this is a C shift, right? I mean, that's why there needs to be training on the coverage piece, even though ultimately, I think in a day-to-day activity, the coverage actually should not take that long to decide, and that's why we moved to the other. Like someone, again, on this hotel thing, and someone was saying, well, what about someone who has an impairment and they give up this really bad body odor and, you know, and they wanted to be a, you know, the receptionist desk or what person. And it was interesting because even though I was doing a webinar with this management lawyer, Commissioner Lipnick, and even though the management lawyer had before just said, go to the merits, she had been saying, when she got that question from the, you know, from the phone, she like went to her default of, well, I guess the first question is the person covered, you know? And then I said, no, don't have that be your first question, okay? Your first question would be, okay, we're going to assume for the moment that you've got some physical impairment that might in fact rise to the level, you've got a disability. Now let's look at the job. Are you stocking something in the back, in which case, big deal that you've got the body odor, or are you a receptionist clerk where that would be a big problem? Just move to the merits, move to the merits. If there's one thing you can tell your folks, and for you guys to do is, don't worry so much that a broken leg is covered. Just go like, take a deep breath, be zen, it's covered, okay? Now let's move to what are they asking for? You know, and can you do it? And is it an undue hardship? And it's really the best, just keep saying zen, zen. Okay, we need to get a microphone to this person, and then we're going to wrap up.
Hi, I don't really want to get into the weeds. I know we're sort of having that problem a little bit, but your just last example made me think of this question where you're talking about qualification standards and being really clear on what your qualification standards are, but when you have something like your example, I don't think most people put needs to smell nice in their qualification standards.
Correct.
So how would you go about making sure that your qualification standards cover you in a way that is complete, or are certain things just sort of known or unknown? How would you do that?
Yeah, I would not spend a lot of energy trying to create qualification standards now. What I would do is go back and look at the ones you've got to make sure they make sense. But beyond that, because it is such an individualized assessment, the most important thing is that for every job in the agency, a supervisor should be able to say, and it can be written in a job description or not, it doesn't have to be, they should be able to say, this job exists to achieve X. Not how you did it, not what you, just be able to say, this is the purpose of this job. Okay, that's the most important thing. Because then, as different people with impairments come, they might need an accommodation. So long as you have that as your compass, what is it that we're trying to achieve? As opposed to how have we done it, what have we said the standards are, da-da. You have what it's designed to achieve, that's going to be your best way to figure out whether you can make an accommodation. So I'll end with this example also from that just happened to have done the hotel one sort of recently. Let's say you have people who are moving chairs into the banquet hall. And the way you've always done it is you've always had people take 5 chairs at a time, right, to go in. Someone has a condition, they can't do 5 chairs. They can't lift it. But they can actually put 25 chairs on a dolly and push them in. okay? The job should not be described as being able to lift the equivalent of 5 chairs. That's like a qualification standard. No, it's what's the purpose of the job? The purpose of the job is to get a banquet room set up in X amount of time, which requires transporting X number of chairs to that room in X amount of time. Okay, that's what you want to do. What are we trying to achieve? And then you'll see if there's an accommodation that'll let the person do that, even if it's not the way it's always been done. So that's eyes on the prize of what are we trying to achieve in the job. And that will get to what I was saying before. The whole point of the ADA is to let people who happen to have physical or mental impairments but who can absolutely do the job get a chance at doing the job. That's the point of it. So we can all get a paycheck and go shopping. No. Okay. Thank you so much, guys. Thank you for your work.
Thank you.
And
Thank you very much for sharing your knowledge with us. Just a few housekeeping items before we go. As I said at the beginning, I'll email the PowerPoint out to everyone who registered and RSVP'd for this event. If you showed up but you weren't on the RSVP list, you're not going to get a copy of it. So if you want a copy of it, send an email to that email address, federaltrainingandoutreach@eeoc.gov, and let us know what you want, and we'll send you a copy of the PowerPoint. I heard Commissioner Feldblum say a brown bag on reasonable accommodation would be great, and I think that's a great idea. If you have other ideas, thank you very much. If you have other ideas for brown bag events, send us an email, and we'll take those into consideration. Last